Thank you, everyone, for joining us for this episode of US Law Live. This podcast is brought to you by US Law's official corporate partners, SEA, American Legal Records, Arcadia Settlements Group, Immersion Legal Jury, Marshall Investigative Group, and MDD Forensic Accountants. We very much appreciate your support and partnership. My name is Jessica Dark, and I am with the U.S. Law member firm Pierce Couch in Oklahoma. I am here with my lovely podcast co-hosts. Nick, give us a short intro.
Hey everybody, Nick Roush from Larson King in St. Paul, Minnesota. Happy to be here.
And the fabulous Pam Halford.
Pam Halford here from Dothan, Alabama, with the Alabama firm of Carr Allison, and happy to get started again with a fabulous guest today in Earl Houston from Memphis.
Earl is from our Martin Tate firm in Memphis, Tennessee. And Earl, how are you doing?
I'm doing great. I'm happy to be here with you.
Well, we are so glad to have you. This is just a fun podcast that US Law has put together to encourage everyone in the network to get to know each other even better, to talk about legal and non-legal topics. So as we get started, just give us an overview of who Earl is and what Earl does.
Well, as Pam stated, I'm located in Memphis, Tennessee. My family and I, we live outside of Memphis in an area called Lakeland, Tennessee. It's kind of on your way to Nashville if you've ever been through this area. I grew up in Mississippi, Pontotoc, Mississippi. Pontotoc is also the county. I spent all of my life in Mississippi up until I graduated from law school. That was in 2005, and then moved to Memphis. Didn't think I was going to move to Memphis. My wife at the time, who's also a lawyer, did not want to live in Jackson, Mississippi. So I resigned from a job that I had accepted down there with the Attorney General's office, and we moved to Memphis without a job. And once I arrived here, we were able to network, and I ended up here at Martin Tate, and I've been here for 18 years.
Now, Earl, are there lakes in Lakeland,
Yes,
Mississippi?
so I do not live on the lake, which was a stupid decision by me. But I am next door to the lake. So I can literally walk through the woods behind my house about 50 yards, and I'm at the lake. When we moved out there, I was really young in my career, and I was working a lot, wasn't really thinking about lifestyle and where I wanted to live one day. I was more so thinking about that I did not want to live in the city from how I grew up. I grew up on a farm. So when we moved out there, I just decided to move as far out as I could without my wife complaining. So that's how we ended up in Lakeland. I did not move on the lake because of the cost at the time, but now I realize that was the biggest mistake ever because I love to fish. And
Tell
that
us
would be
about
the
the
place
farm
for it.
you grew up on. Sorry, I didn't mean to cut you off, Earl.
So I grew up on a cattle farm. It was small compared to the farms around us. We probably had 100 head, and then we farmed about 400 acres. So my dad was a part-time farmer. He also worked at Cooper Tire Rubber Company. And then my mom owned a salon. Well, I called it a beauty shop growing up. But
Does that mean that you like to don a cowboy hat, Earl?
no, I don't go that far. My family, now I have some hats that I've inherited. My family does. We had horses too, but I didn't ride. I learned early on, man. ATVs came out, and I got my first one. And I was like first grade, and from that point on, I was an ATV guy. Horses, I fed them and I worked with them, but I did not ride them.
Have you defended any ATV cases, Earl?
Never in the ATV cases, but my knowledge of farm life and cattle and so forth, it did help me, or it has helped me with defending cattle haulers. So on the transportation side, your cattle haulers, I understand what they have to do in order to survive that industry.
So Earl,
Is that,
oh, go ahead, Pam. Go ahead.
I'm sorry, is that your main area of practice, Earl? I know you and I tend to cross paths in the U.S. law transportation space, but is that primarily where your practice focuses?
So transportation is probably about 50% of my practice. The rest of it includes premises. I mean, I have some employment cases. I have some professional negligence cases. I have business dispute cases. You name it, I've handled it. The only thing I haven't done is worked on the plaintiff side very much. I've handled 2 plaintiffs cases, and they were for current clients.
Earl, when I was doing my very intensive research for this podcast as your host, I read on your website that you serve on the Tennessee Board of Court Reporting. And I was very intrigued by that, 'cause I don't know if Oklahoma has one. Maybe we do. But how did that come about? What does that entail? Just tell us a little bit about that.
So I no longer serve on that board, but years ago,
You need to update our website, Earl.
I do need to update my profile. Thank you for pointing that out.
Anything we can do here on U.S. Law Live.
You're certainly helping me. So early on in my career, I had an opportunity to meet the governor. And at the time, the legislature was, they had legislation to establish guidelines and rules for court reporting, our court reporters in our state. They wanted our court reporters to be licensed to protect the written record. And so legislation passed, and they created a board that was comprised of, I believe, 3 reporters, 2 lawyers, and 2 judges. And I was one of the lawyers that was chosen for that board. And I served on that board for, I think, 8 years. During that time, we established the rules and regulations that court reporters would abide by. And then we established all of the fee requirements that would relate to licensure and then renewal of licenses. It's my understanding, though, because that was several years ago, it's my understanding that there may have been legislation recently to revise the law on licensure. I haven't kept up with it in detail, but I do know that there was some, because the reason I know that is because there were some lobbying groups that were calling me about my thoughts on the issue. So that's how I discovered the issue, but I didn't have a lot to offer them considering I hadn't been on the board in many years.
Very cool. I know we all really appreciate our court reporters, and I know that they have always had very interesting stories about witnessing dialogue, maybe discussions, maybe arguments. Earl, have you ever gotten into an argument in a deposition where the court reporter said, "Oh my gosh, I've never seen anything like this"?
I actually have. Believe it or not, people find me to be difficult to work with sometimes.
No.
Not you,
I
Earl.
cannot
Not
believe
you,
that.
man.
Tell us what happened.
Well, I had one case about 4 or 5 years ago where it was a very highly contested case. It was an extreme high value case. Lots of depositions were taken. We had 48 hours of discovery dispute calls. Honestly, I thought that case would probably hurt my career because I just knew that I was going to be in the newspaper with some huge verdict hanging over my head. But fortunately, we got the case resolved. The lawyers on the other side, they they did their job. They were adamantly representing their client to the best of their ability, but it did cause some anger issues in the case, and I'm pretty easygoing, but I have not gone out to dinner with them. There have been invites, but we have not. I have not accepted. So we can say that.
I just wouldn't take you, Earl, as that type, but maybe I think all of us on the call have had an experience like that. So Earl, the way that our podcast is set up, our next section is on a legal topic, and usually we have our guest bring us the topic to discuss. And I know off the record before we started, you talked about there were a few things that you wanted to talk about, or at least in your neck of the woods in Tennessee. And so we'll, I guess, open the floor up to you to start the discussion.
Well, I'll say that, but let me say this before, because I do need to clarify my last statement. So I do believe in collegiality amongst lawyers.
Totally.
I do think that the best way for the bar to survive the issues that we sometimes see in our cases is for at least the lawyers to understand that what happens in cases are not personal. For that reason, I am chair of our Memphis Bar Association bench bar this year, and one of my goals is to have more socials amongst the lawyers. So every day there's going to be a social hour that is sponsored by a restaurant or bar to make sure that we kind of foster the relationship between lawyers. Now, with the issue that you raised, I would say that the biggest issue that I see now in Tennessee, I see it in all jurisdictions. I see it in Arkansas. I'm not licensed in Arkansas, but I do have some cases that come through every now and then in Mississippi and Tennessee, is future medicals. Everybody's putting together these life plans now that provides for future medicals throughout the term of, or the potential term of an individual's lifespan. And that causes me concern. It used to be that when I would get a case in, I would make assumptions on what our defenses are going to be and try to make sure I have enough evidence to support those assumptions. But now on the liability side, from the very beginning, I have to worry about damages, because you may have a plaintiff that has $25,000 in meds, and you'll think, oh, this is a low to medium value case, mid value case, and that's how you will handle the case, because you'll be more focused on making sure you can bring down the value of the case through your comparative fault defenses on the liability side, as opposed to focusing on the damages, because your damages are not astronomical. But what ends up happening is, once you're 3 to 6 months into the case, then all of a sudden you receive this life care plan for future medicals. It's typically a couple of weeks before your mediation takes place. And when you get that, you're looking at it and you're like, wait a minute, my plaintiff is 35 years old, and they're saying that she's going to need this drug that's going to cost her $800 a refill until she's age 72. And then she's going to need, over that period of time, she's going to need another 10 injections in her neck. And before you know it, you're looking at a life care plan that's anywhere between $250,000 and $500,000. And those are hard medicals that you have to contend with before a jury. So you'll look at a jury verdict form, and I did this before today in preparation for our podcast. I just ran Tennessee verdict across the state on the reporter, Googling it, and I found at least 10 cases, 10 verdict forms, and all of them had anywhere from, in core economic damages, meds, core meds, they had between $15,000 and $35,000 in medicals that were awarded on the verdict. But when you looked at future medicals, and out of the 10 or 15 that I reviewed, at least 6 of them had future medicals, and they all came from various firms that we work with all the time. Your future medicals award on the verdict form was typically 3 to sometimes as much as 8 times what the medicals were. And that was shocking to me. I mean, you think about how much that increases a verdict. Now in Tennessee, future medicals cannot be speculative. They have to be pled with specificity and certainty. So in other words, you have to have an expert, but your expert has to base the basis for future medicals on a valid reason. And it has to be something that relates to treatment and not pre-existing issues. It has to be something that relates to causation. So from that standpoint, I would urge everybody, and no matter what your jurisdiction is, to make sure that from this point forward, at least in the new litigation landscape that we live in, to make sure that when you first receive a file, that you not only look at what your liability defenses are, but you start establishing a pattern of asking opposing counsel for an update on medical status and or a settlement demand as early as you can, because what that will do is it will give you an understanding of what they plan to allege. It will also give you a basis if at any point in time you get any information stating that medical treatment is complete, it will give you a basis for an argument to say then if medical treatment only lasted X amount of time and you consider the individual in a position or in a position where medical treatment is no longer required, then why is it that they require future medicals? So little things like that, just make sure that I would say to all defense counsel out there, make sure you're on top of those issues, because all of the big verdicts that we see now include future medicals.
It's a good point, Earl. We had a case too, and a few of them where we were told by the mediator that the plaintiff's lawyer wasn't even focusing on past meds, right? But they had an astronomical number on future meds. And I think it was interesting. I've had 3 mediations now in the last 6 months where that's happened, where I've said, how can this potentially be? They're at 15K, 20K, 30K, or barely over the PIP, whatever it is, of meds. And the mediator says, Nick, you're not understanding. They aren't even going to blackboard that number, but they are going to blackboard the 7 to 8 figure life care plan that's in front of them. And so I'm curious, Earl, just in your litigation strategy, I think all across the country, Oklahoma, Alabama, Tennessee, Minnesota, we probably all do this differently. When you get into litigation, Earl, how are you combating those life care plans, and what steps do you usually take through litigation to sort those out?
So you have to start looking at the medicals in depth. I always ask for plaintiff's counsel, one, in an interrogatory to list all physicians that have treated the individual for the last 10 years. Now, they're not going to produce all of those names to me. They're going to leave people out. It's inevitable. So I will also ask them to produce.
They would never withhold information, Earl.
I don't know. I tell the truth about things. It's never there. And I don't know if they're intentionally doing or if it's by mistake, but it's never there for me. So what I end up doing after that is I will take the medicals and either a paralegal in my office, most of the time it's a paralegal, or sometimes I will use a third party. They will go through the medicals and I will ask them to look for keywords, degenerative issues. I will ask them to look for if there's any note in a record about prior treatment. Because what I'm looking for is every medical provider that's treated that individual in a period of time. Sometimes I ask for medical canvas, depending on the case and the facts of the case. The goal is to find as much information as you can about the party's medicals before you depose the party. Now, I'm not going to use the medicals necessarily in deposing the party because I don't want to put those records at issue in the case for plaintiff's counsel. What I will do is use the records to create my questions for the deponent. And I may just ask them, hey, you ever had this issue? Or if you play any sports, when you play in sports, did you ever injure this part of your body? And if they say no, then I know I've got the medical record down the road to use to impeach their testimony. So that's how I try to attack the life care plans. And I will use those medical records. If I depose the individual who drafted the life care plan, I might use those medical records with them. But I won't use them enter them as an exhibit with the deponent.
I think that's great, and that gives good perspective on different ways we can use those medical records. They're incredibly important on us. So Earl, we are about 6 minutes away from time. We're going to transition now to our last topic, which I think is a little more lighthearted than maybe some of the other ones. Thank you so much for that insight on life care plans. It's a really good lesson, I think, for really all of our folks that do any type of tort work. I want to ask you, Earl, we talked off the record, and you and I had a shared experience of not thinking we were going to go to law school and then ending up in law school. And so I'm curious kind of what your career trajectory was, Earl, before going into law school, and what led you to end up practicing law.
Well, I started out, growing up in the South, every parent wants their kid to be a doctor or a lawyer. Neither one of my parents went to college. So they were adamant that my sister and I go to college. I have a sister that is 12 and a half years older than I am. So they had her when they were really young, and then they had me later in life. So my sister went to college when I was first grade. So 1985, she graduated and went into college. So I got to see her go through college. She went away to college, so we saw her once every month or two, something like that. And he was always excited because I think she was like a second mom to me from an age standpoint. So that was pretty exciting. So I knew I was going to go to college. So I ended up at Ole Miss, and while there, I was pre-med major, a biology major. Wasn't doing as well, making C's. And so I figured that wasn't going to cut it. So I ended up switching over to political science. And so I did political science with a minor in terrorism. And I had this thought that I was going to go to the FBI. I did get recruited by the CIA, but I didn't make the cut. They didn't call me back.
Special Agent Earl Houston sounds really good.
Hey,
that's what his name tag is going to say forever moving forward.
Special Agent Earl Houston. I love it.
I took a test with two other individuals, and I didn't know their names. They were on campus. Never saw them again, honestly. But I took a test with them, and never heard anything. So, and they came to me. But I'm assuming that I either failed the psychological exam or failed the test.
They're just
one or
biding
the
their
other.
time. They'll call you any day now.
So then I graduated, and I was going to take a job with Merck Pharmaceuticals. And parents didn't want me to do it. They were offering me a position as a sales rep in New Orleans. I was excited about that because I spent spring break down there a couple of times. And so I was excited about going to New Orleans, but My parents wouldn't, they weren't sold on it, and they were telling me all these things that they were going to do if I decided to take this job. So I didn't take that job. There was a girl that I knew that had gone to work for Hershey's over in Alabama. And that was another job offer that I had. Parents didn't like that either. So I didn't end up over in Alabama. So I ended up taking
Roll Tide, Earl. Roll Tide. Roll Tide.
I ended up working at a bar for 6 months. I played saxophone, so I played in a couple of bands, and I was a bartender and a bouncer. I did that for 6 months over in Oxford, and I had a buddy that was going to Memphis to take the LSAT, prep course for the LSAT. I hadn't registered for the LSAT, hadn't done anything. He told me I should do it. I had another buddy that had a girlfriend that lived in Memphis, and he wanted to go see her. So we all came to Memphis, and we hung out on Beale Street and did some other things. The next morning, I went over to the prep course, and they allowed me entry on the spot. So I did that, and then I took the LSAT, and I ended up in law school. Didn't do well my first year, wasn't focused. Then after that, of course, I met Ayanna in law school. She was very focused. Changed my study habits, and graduated. And
Does that mean you were looking at her notes and her outlines, Earl?
well, I will say this. So I was good at memorizing information. I was not very good at organizing and being very astute at time requirements. So I thought in law school, you take one exam at the end of the year. I figured that I could wait till 3 weeks out and then memorize all of this information. And it just didn't work out for me.
That's
So that's
stressing me
why
out.
that's why I didn't do well. It worked in undergrad. Undergrad, I had very good grades, but in law school, it didn't work out for me. So yes, Ayanna was very good at keeping up, updating outlines, and doing all of those things. The group that she studied in, they were all on law review. And so when she brought me into that group, it helped me, and it showed me what I should have been doing. And so my second and third years, I did pretty well in law school, and that saved me. But outside of that, I don't know what would happen.
Well, we're glad that she pulled you in the group and pulled you through law school, Earl. You are a wonderful asset to U.S. Law. We're so glad you could be here with us today. I want to thank everyone for listening to U.S. Law Live. Stay tuned for more great conversations on U.S. Law Live, the official podcast. To learn more about U.S. Law Network, visit uslaw.org. Thank you, Earl.
Thank you. Enjoyed it.